Hey everyone, Jonathan Ratchik here, partner at Kramer, Dunleavy Ratchik in New York City. So if you've lived in New York City for more than a week, you already know that. You already know this, that our sidewalks can feel like a veritable obstacle course. One minute you are walking to the subway, the next you're dodging a slab, sticking up like a speed bump, and or stepping around a crater-sized hole, or maybe even navigating concrete that looks like it survived an earthquake. And most of us shrug it off until someone gets hurt. And when a fall happens, it's fast, it's violent, and it can change everything in an instant. Broken bones, torn ligaments, head injuries, these aren't rare. They happen every single day. But here's the part that most people don't know, which is that when a sidewalk is dangerous, the law automatically does not blame the city. And in fact, it's the rules about who is responsible and who pays for the harm caused by a dangerous sidewalk that are very specific and oftentimes very misunderstood. So today I'm going to break it all down in plain English. Okay, who's responsible for a dangerous sidewalk? What the law actually requires, what offenses property owners use to avoid responsibility, and what you should do in the unfortunate event that you're injured. So let's get into it. So again, sidewalks, they crack, they buckle, they sink, they break. Trees push up slabs. Delivery trucks jump curbs. Construction workers leave surfaces uneven. And because millions of people walk these sidewalks every day, even a small defect, a raised edge, a deep hole, can cause a serious fall. And they're resulting in significant injuries. Okay. I've seen in my practice broken wrists, broken elbows requiring surgery, torn ligaments in knees, fractured hips, brain injuries. A fall on a concrete sidewalk can be a very serious event. And most people assume that the city of New York is the one responsible for maintaining the sidewalk. But actually, in New York City, it's the property owner of the adjacent property owner who's the one who is responsible. So under New York City's Administrative Code, the owner of a property adjacent to a sidewalk has to maintain the sidewalk in a reasonably safe condition. Okay, that means fixing cracks, leveling uneven slabs, repairing holes, keeping it free and clear of snow and ice, and basically preventing tripping hazards. And if they don't and someone gets hurt, the property owner, not the city of New York, is the one responsible. Now, there are some exceptions to this rule. Okay, if the sidewalk is adjacent to a one, two, or three family home that is owner occupied and used exclusively for residential purposes, the city will still be responsible. Okay, or if it's next to a city owned building, okay, or if it involves a tree curb or a curb or a tree well, the city is responsible. Okay, but for commercial buildings, multiple dwellings, co-ops, condos, restaurants, stores, more often than not, it's the owner who is responsible for that sidewalk. Now, what counts as a dangerous sidewalk? There's no hard measurement under the law as to what constitutes a safe versus an unsafe sidewalk. Okay, really the question is, would a reasonable person consider the sidewalk unsafe? And some of the examples, which I've already mentioned, a slab that's raised high enough to catch your foot, maybe a deep hole or a missing piece of concrete, a patch job that created a new hazard, or an elevation differential. Okay, it's about common sense and foreseeability. And even assuming, however, that a sidewalk is dangerous, there's still one major issue, and that is the issue of notice. Okay, and the best way to describe notice is one of fairness. Okay, the law only holds someone responsible for a dangerous condition if they had noticed, if they were aware or should have been aware of the condition. Okay, because it's arguably not fair to hold someone responsible for a condition that they either didn't know about and or should not have known about or could not have discovered. And there are two types of notice. Okay, there's actual notice. Okay, this is if the owner knew about the problem. Okay, maybe someone complained to them about it. Maybe they saw it themselves, or their super or porter saw it and they just never did anything about it. And there's also constructive notice. Okay, if an owner is claiming that they didn't know about it, but maybe that dangerous condition existed for a long enough period of time, such that in the exercise, take that back, existed for a long enough period of time and was visible, so that in the exercise of reasonable care, the party responsible should have discovered it and corrected it. So that can be an uneven sidewalk that's been there for months, maybe a slab that's been raised by tree roots for years, a hole that clearly didn't form overnight. Okay, so if the condition was visible and existed for a sufficient length of time, that's constructive notice. Okay, now even when there is notice, and oftentimes it's clear as day that the owner either knew or should have known about the condition, owners and insurance companies rarely accept responsibility without a fight. And some of the defenses that we see most often are, the first is the defect was trivial. Okay, this is a common defense. And the argument is essentially that the defect was too small to be dangerous, basically saying, it's just a tiny bump. But again, the law does not set a magic number on what is or is not a trivial defect, okay? A small height differential can still be dangerous depending on the lighting, the weather conditions, how much foot traffic there is, whether it blends in visually with the surrounding sidewalk, okay? It's all about the totality of the circumstances. And that's why it's really important early on to, I'll get to that later in the video, but there's steps that one should take in order to rebut this defense, okay? Another common defense is it's open and obvious, okay? That basically this condition was so glaring and apparent that you should have avoided it, okay? But again, a condition that is open and obvious when there's no one else on the sidewalk can still be dangerous, okay? Look, pedestrians we don't walk around New York City looking at the ground all the time, okay? We walk normally, we carry our bags, we're looking ahead, we're watching out for traffic, window shopping, okay? So open and obvious doesn't automatically get the property owner off the hook. It's totality of circumstances. Maybe they claim that they had no notice about it. But again, if a defect existed for a long period of time or was clearly visible, they might arguably be charged with constructive notice of the condition. The pedestrian wasn't paying attention. They try to blame the injured pedestrian. They were distracted, looking at their phone, whatever it was. But even if someone is partially distracted, that doesn't negate or erase the property owner's responsibility, okay? At most, it rises to the level of comparative negligence. And this is the more important one, it wasn't our sidewalk, okay? Maybe it's in front of someone else's property, or maybe the city was responsible. That's why identifying the exact location of an incident is really critical in this type of litigation. So in the unfortunate event that you fall and get injured on a sidewalk, here's what one should arguably do to protect their rights, okay? One, needless to say, this is on top of getting medical attention immediately, okay? Injuries certainly show up sooner rather than later, but you never know what happens if you've been involved in a fall. Sometimes that achy knee, maybe it doesn't go away, and it's better to get medical attention sooner rather than later, and also to document that the incident actually occurred, right? This is one of the boxes that insurance companies check in assessing a case, okay? Did it actually happen? Did they seek medical attention right away? What was the history that they gave to the emergency room or to the urgent care? But in addition to getting medical attention, take photographs of the condition, right? A photograph is worth 1,000 words, okay? So close-up photographs of the condition, photographs to put the condition in context, maybe putting something down so that you can gauge the dimensions of it, maybe a credit card or a Metro card if you still have one. Identify the building in front of which the incident took place, okay? Because again, responsibility depends on who owns the property adjacent to the sidewalk, okay? So getting the exact address of the adjacent property owner is really critical in identifying the responsible party. Get witness information, okay? I always say this, if there are witnesses to the fall, not only get their names, get their cell phone numbers and their email addresses. Even though people in this country, we move around a lot, the one thing that people don't change are their cell phone numbers and their email addresses. Don't ask me why, people just don't do it. Report the incident if it's possible, whether it's to the building in front of which you fell, or you can even call 311, okay? But again, that's about documenting the occurrence of having taken place, because that is important when an insurance company and their attorneys are determining whether or not it actually happened, okay? And certainly, last but not least, speak to an attorney sooner rather than later, okay? Sidewalks get repaired, surveillance footage gets overwritten. A lawyer can take steps to preserve critical evidence before it disappears, okay? And again, sidewalks, they ought not to be dangerous, okay? But when someone gets hurt because a property owner didn't do what they were supposed to under the law and maintain the sidewalk in a reasonably safe condition, the law gives the injured pedestrian the right to hold them accountable. So if you or someone that you know was injured on a New York City sidewalk, feel free to contact and reach out. My team here at Kramer, Dunleavy Ratchik, we're here to help. you understand what your rights are and guide you through what could otherwise be a very complicated and time-consuming process. So again, Jonathan Ratchik, Kramer, Dunleavy Ratchik, experience you expect, commitment you deserve. Thanks for watching.